So today we are going to continue with our discussion on asymmetric federalism, and if we get time, we will commence our discussion on another important concept that we will be discussing, that is basic structure. Okay. I hope some of you went through some of the readings that were uploaded on the classroom.
मैम आपकी वॉइस क्लियर नहीं आ रही है.
अच्छा, अब सही आ रही है? अब आवाज आ रही है?
Yes ma'am.
Okay, so what we were discussing was that yesterday we were discussing this concept of asymmetric federalism, and I told you that we will be try to briefly summarize three of the examples, these three examples that indicate that India has some elements of asymmetric federalism, that is fifth and sixth schedule, obviously, then Article 370 and the special provisions under Article 371 to 371J. Now, let us start our discussion with fifth and sixth schedule. I hope you have the bare act of the Constitution in front of you, open in front of you, and I would like to request all of you to open your bare act to the fifth and sixth schedule. Schedules are provided towards the end, after the provisions or the articles conclude. Schedules are provided towards the end of the Constitution. Now, if you open fifth and sixth schedule, you will find an elaborate fifth schedule. Now, if you look at that, and fifth schedule is deriving its part from Article 244 Clause 1. So, let's start with a reading of Article 244 Clause 1. Okay. Now, what does 244 say, which is a part of Part 10 of the Constitution, that the provisions of fifth schedule shall apply to administration and control of scheduled areas and scheduled tribes in any state other than the states of Assam, Meghalaya, Tripura and Mizoram. And the provisions of the sixth schedule shall apply to the administrations of the tribal areas in the state of Assam, Meghalaya, Tripura and Mizoram. So, while fifth schedule is for the administration of scheduled area and scheduled tribes in all the states except the four states mentioned in 244(1), sixth schedule is for the administration of scheduled areas and scheduled tribes in the four states which are excluded from Article 244 Clause 1. Okay. So basically, the objective of both fifth and sixth schedule is the same, but because the treatment of scheduled areas and tribes in Assam, Meghalaya, Tripura and Mizoram is a little different from how scheduled areas are given powers and autonomy in other states. That's why we have a separate schedule dedicated to them. Again, an example of asymmetric federalism, right? That's how scheduled areas in some areas are given, apart from these four states, are given a different treatment as compared to scheduled areas in the four states mentioned in sixth schedule. Now, if you look at the schedule, it says that if you look at the schedule and if you look at the third point of the schedule, third provision of the schedule, it says the governor of each state having scheduled areas therein shall annually or whenever so required by the president make a report to the president regarding the administration of scheduled areas in that state, and the executive power of the union shall extend to the giving of directions to the state as to the administration of the said area. So, union executive has the power to direct the state as to how those scheduled areas, which have been declared as scheduled area in any part of the country except Assam, Meghalaya, Tripura and Mizoram in fifth schedule, can be administered. Now, like I mentioned to you yesterday, we have this constitution of something called a Tribes Advisory Council in scheduled areas. Now, as we discussed yesterday, why do we need a constitution of scheduled area? Scheduled area have been created so that the main reason for the creation of scheduled area is so that the indigenous tribes in those areas can be given protection, and they can be treated differently from other areas in the country because first of all, most of these scheduled areas belong to socially and economically backward class, and that's why special treatment has to be afforded to them. And secondly, also because so that the mainstream cultural does not dominate the culture of these scheduled areas, and they are able to retain their own cultural distinctiveness, certain exceptional treatment is provided to these areas, right? So that is the main purpose. So what if you look at Part B of the first schedule, you will find the constitution of Tribes Advisory Council. Now, what is the Tribes Advisory Council? If you look at the text of Part B of Schedule 5, it says that there shall be established in each state having scheduled areas therein, and if the President so directs, also in any state having scheduled tribes but not scheduled areas therein, a Tribes Advisory Council consisting of not more than 20 members, of whom as nearly as maybe 3/4 shall be representative of the scheduled tribes in the Legislative Assembly of the state. Provided that if the number of representatives of the scheduled tribes in the Legislative Assembly of the state is less than the number of the seats in the Tribes Advisory Council to be filled by such representatives, the remaining seats shall be filled by other members of those tribes. So this Tribe Advisory Council is basically going to have those representatives of specific scheduled tribes who are members of the State Legislative Assembly. And in case the members of State Legislative Assembly are not sufficient to or members of scheduled tribe members will in the State Legislative Assembly are not sufficient, then other members from the specific scheduled tribe is going to become a part of Tribe Advisory Council. Now, what purpose does this serve? That this Tribe Advisory Council can voice wants and aspirations of those areas and people living in those tribal areas, and basically ensure that act as a bridging gap between the scheduled tribe areas and the government. So that is the entire objective of this specific fifth schedule. Now, similarly, if you look at sixth schedule also provides for Vinay, what the provider says is that let's say that, now what does it say? That at least three-fourths member, Tribe Advisory Council will have not more than 20 members, okay? If you look at the main provision, of whom as nearly as 3/4 shall be the representative of scheduled tribes. That means that if you look at 3/4 of 20, that means if there are 20 members in a Tribe Advisory Council, 15 members have to be members of or representatives of the scheduled tribes. That means 15 members have to be representative of the scheduled tribes, right? Now, those 15 members, as the main provision says, 3/4 shall be the representative of the scheduled tribes in the Legislative Assembly of the state. So those representatives of the scheduled tribes who are also the members of the Legislative Assembly of the state are going to be the members of Tribe Advisory Council. But there is a probability that 15 members, there aren't 15 representatives of those scheduled tribe in the State Legislative Assembly. There are only 10 members, 10 representatives of those scheduled tribe in the State Legislative Assembly. Then how are you going to fulfill that 3/4 criteria? In that scenario, the remaining 5 seats out of the 3/4 is going to be filled by other members of those tribes. Even if they are not representatives in the State Legislative Assembly, they are going to be the members of that. Members of the tribes are going to be a part of Tribe Advisory Council. So for those 5 members, this requirement in the main provision of Section 4 of the 5th schedule is going to be done away with. I hope that clarifies the proviso, Vinay. Now, what is the duties of Tribe Advisory Council? As I told you, and as is mentioned in Part B itself, to advise on matters regarding to welfare and advancement of scheduled tribes. Okay, so these are this is an important aspect, because then this Tribe Advisory Council actually serves as a bridge between the scheduled tribe and the government, and the requirements and the needs of the scheduled tribes are conveyed through this Tribe Advisory Council to the government. So what we see is that there is sort of a differential treatment given to scheduled areas and scheduled tribes. Now Section 5 of the Schedule 5 is extremely important, because what it says is that notwithstanding anything in this constitution, the governor may by public notification direct that any particular act of parliament or of state legislature shall not apply to a scheduled area or any part thereof in the state, or shall apply to a scheduled area or any part thereof in the state, subject to such exceptions and modifications as he may specify in the notification, and any direction given under this paragraph may be given so as to have retrospective effect. That means that, okay, yes, Vasant, the first preference is for members who are representatives of the scheduled tribes itself, by those representatives of scheduled tribes who are also members of the Legislative Assembly. But in case you cannot fulfill that 3/4 requirement, and there aren't, let's say, 15 members in the State Legislative Assembly who are representatives of scheduled tribes, in that scenario, the remaining vacancy will be filled by the members of the scheduled tribe itself. So yes, the first preference is obviously to those representatives of scheduled tribe who are also the members of State Legislative Assembly. That is very clear from the provision given under Part B. Now let's come to the fifth provision, which is given under Part B of the fifth schedule, which basically says that certain laws are not going to be made applicable to certain areas in scheduled area and scheduled tribe, scheduled areas. Now, why is so the governor can direct by a public notification that certain laws, okay, will not be made applicable to scheduled areas. So even if a law is, let's say, applicable across the territory of India, there can be an exception made with regard to applicability of that law in scheduled areas. Now, what is the reason behind this? Because sometimes laws are made regulating different cultural aspects and religious aspects of one's life. Now, those laws, if they contradict with the culture of such scheduled areas, may sort of dilute the cultural distinctiveness of these areas and these tribes, and therefore there can be a provision. Governor through public notification can decide or can formulate that certain laws which are otherwise applicable across the territory of India would not be applicable in these scheduled areas. So that is again a differential treatment, right? Something we studied in asymmetric federalism. That we are not going, that certain areas and certain provinces are not given the same treatment as compared to other areas and provinces. Now this would not happen for those areas which is not a scheduled area. This is something which has a special provision made for applicability of law vis-a-vis scheduled areas. Okay. Now, apart from that, if you look at the fifth provision of fifth schedule, it says that the governor may also make regulations for the peace and good government of any area in a state which is for the time being a scheduled area, and in particular and without prejudice to the generality of the foregoing part. Such regulations may prohibit or restrict the transfer of land by or among the members of the scheduled tribes in such area, regulate the allotment of land to members of scheduled tribe, regulate the carrying on of business as money lender by persons who lend money to members of scheduled tribes in such area. So what does it do? So a law, for example, can be made in scheduled area wherein everyone does not have the right to freely buy property, okay, which is there in many of these scheduled areas. So the land of the scheduled area actually only belongs to the scheduled tribe. In order to protect those lands from being protect the cultural distinctiveness of the scheduled area, certain laws regarding allotment of land, transfer of land, even prohibiting transfer or restricting transfer of land, etc., can be made in these scheduled areas. So, the crux, if you look at the crux of Schedule 5 of the Constitution, what you will find is that certain kind of exceptionalism is provided to such scheduled areas. Now, what is the meaning of scheduled area is given under Part C of its schedule, and what is said in the Constitution is that in this Constitution, the expression scheduled area means such area as the person may by order declare to be scheduled areas. Now, if you look at the footnote of this specific provision, at least if you are having Universal Spare Act, you will have a footnote, and the footnote says, what are those, it gives an example of such orders. For example, Scheduled Area Part A states, Scheduled Area Part B Order 1950, Scheduled Area Himachal Pradesh Order 1975, Scheduled Area Bihar, Gujarat, Madhya Pradesh, Odisha Order 1977. So basically a presidential order. President, that means the central government. So it is within the power of the central government to declare which of the areas in the state in India will be considered to be scheduled areas. And once an area is declared as scheduled area, that will automatically fall within the ambit of Schedule 5 of the Constitution, unless and until obviously those scheduled areas pertain to the 4 states, namely Assam, Meghalaya, Tripura and Mizoram. So if the scheduled areas in Assam, Meghalaya, Tripura and Mizoram are governed by Schedule 6, but apart from that, through presidential order, areas can be declared to be scheduled areas. So now, another important aspect, and so something which will become further clearer when we discuss the amendment of the Constitution. The amendment is not a part of your syllabus this term, but because we will be studying basic structure, so we will be briefly covering the process of amendment. Now, if you look at provision 7 of the 5th schedule, it says, Parliament may from time to time by law amend by way of addition, variation or repeal any of the provisions of the schedule, and when the schedule is so amended, any reference to the schedule in the constitution shall be construed as a reference to such schedule as so amended. No such law as is mentioned in subparagraph 1 of this paragraph shall be deemed to be an amendment of this constitution for the purpose of Article 368. Now, why is this clarification given in 5th schedule? For that you will have to briefly at least drop of what is an amendment process. Now, once a constitution, there are two kinds of powers which are inherent in the parliament, okay? Not the state legislative assembly, I am saying the parliament. Parliament means the Lok Sabha and the Rajya Sabha. And the president, of course. So the parliament constitutes of Lok Sabha, Rajya Sabha and the president. So, but primarily the power or legislative power, because it is vested in the Lok Sabha and the Rajya Sabha. Now, the parliament has two kinds of power, ordinary legislative power and constituent power. Now, ordinary legislative power is vis-a-vis the power of the parliament to formulate, to enact ordinary pieces of legislation. But constituent power is the power of the parliament to bring about change in the constitution or amend the constitution. Now, constituent power is something which the parliament has been vested with after the dispersal of the Constituent Assembly. But every act of amending the constitution or bringing, and when I mean amend, I am using the word amend in a broader sense. Every act of changing the constitution is not necessarily an exercise of constituent power. Only something that can fall within the ambit of Article 368 of the Constitution is an exercise of constituent power. So that means that, and if the Parliament is exercising constituent power, the Parliament will have to follow the procedure laid down under Article 368 of the Constitution. But if Parliament is bringing about a change in the Constitution, which is not in furtherance of the exercise of the constituent power, it may bring about a change in the constitution by ordinary majority. Now, if you look at Article 368, we have a special majority, right? And we will discuss that later, but it is not an ordinary majority wherein if 50%, more than 50%, it is passed by more than 50%, it would be considered to be an enacted law. So, all aspects of constitution, changes in constitution does not necessarily require an exercise of the power vested in the parliament under Article 368. Sometimes the parliament also can bring about changes in the constitution by exercising ordinary legislative power. And Schedule 5 is an example of ordinary legislative power. That is why 7 clause 2 provision of Schedule 5 says that no law which is made by the parliament in order to add, vary or repeal any provisions of Schedule 5 is going to be considered to be an amendment for the purposes of Article 368 of the Constitution. So basically the Parliament in exercise of its ordinary legislative power can bring about a change under Schedule 5. Bringing about a change under Schedule 5 does not require the exercise of constituent power inherent in the Parliament under Article 368. So that is an important aspect, or this will become further clearer to you once we come to basic structure, and maybe then you have a brief idea of how this basic structure doctrine evolved and what is the relevance of Article 368 in the development of the concept of basic structure. Okay, so I hope at least you have a brief idea of what Schedule 5 is about. Now let's quickly move to Schedule 6. Now if you look at Schedule 6, Schedule 6, as I told you, as is mentioned under Schedule 5 itself, covers 4 scheduled areas in 4 states: Assam, Meghalaya, Tripura, Assam and Meghalaya, and Tripura and Mizoram. So these are the 4 states that are covered under Schedule 6. Now, Schedule 6 sort of, why is there a Schedule 6 in the Constitution? Now, the reason being that scheduled areas in most of the country, and the reason that was given, the reason cited for making a distinction between these 4 states and the other states was that the argument being that scheduled areas in almost all the other states have sort of in some manner merged with the mainstream population. In several aspects and even culturally. But many of the scheduled areas and scheduled tribes in the states of Assam, Meghalaya, Tripura and Mizoram still maintain their unique distinctiveness. and have not merged with the majority population. So what has been done is that in order to ensure that they maintain their cultural distinctiveness, and their cultural distinctiveness is not diluted because of the domination of the mainstream population, more autonomy has been provided to Schedule 6 areas. Now, if you look at just below the mention of the term Schedule 6, there are two provisions mentioned therein. The two provisions being Article 244 Clause 2 and 275 Clause 1. Now, we have already read Article 244 Clause 2. Now, let's briefly have a look at Article 275 Clause 1. Now, what is it that Article 275 Clause 1 talks about? And I hope you have the bare acts in front of you. Now, 275 Clause 1 says, and it talks about, 275 Clause 1 is basically about talking about grants from Consolidated Fund of India to the states, and how these grants are going to be given to Consolidated Fund of India to the state. Now, if you look at the first proviso under 275 Clause 1, it says that provided that there shall be paid out of the Consolidated Fund of India as grants in aid of the revenues of a state such capital and recurring sum as may be necessary to enable that state to meet the costs of such schemes of development as may be undertaken by the state with the approval of Government of India for the purpose of promoting the welfare of the scheduled tribes in that state or raising the level of administration of scheduled areas therein to that of the administration of the rest of the areas of the state. Now, why the specific mention of scheduled areas under Article 275 Clause 1? Because special protection and special provisions are made vis-a-vis scheduled areas, and that's why it's very important that those scheduled areas will have certain specific and exceptional protections. Now, if you look at the sixth schedule basically talks about autonomous districts and autonomous regions. This is the difference between Schedule 5 and Schedule 6, wherein Schedule 5 is only talking about the constitution of Tribe Advisory Council. In Schedule 6, we are going a step further, and also the constitution is making an exception and basically providing that autonomous districts and autonomous regions can be developed. So what is being said is that, subject to the provisions of this paragraph, the tribal areas in each item of Part 1, 2 and 2A and Part 3 of the tables appended to paragraph 20 of the schedule shall be an autonomous district. Now, if you look at Schedule 6, it's a very long schedule, okay? And if you look at paragraph 20 of the schedule, you will find the areas which are specified in Part 1, 2, 2A and 3 of the table. That is the area, the scheduled areas in Assam, Meghalaya, Tripura and Mizoram. And they can be declared to be an autonomous district. So, and the autonomy that will be provided to such districts will be much larger as compared to the autonomy which is provided to districts of other states or the states themselves. And that is the differentiating part between Schedule 5 and Schedule 6. Now, so what we find is that if you look at paragraph 2 of Schedule 6, what you will find is that constitution of district councils and regional councils. Now, each district council for each such autonomous district in these scheduled areas would consist of not more than 30 members, of whom 4 would be appointed by the governor and rest will be elected on the basis of adult suffrage. That means that these autonomous district councils and regional councils in these autonomous tribal areas, only 4 are going to be out of the members in these areas, in these councils, only 4 members are going to be representatives of the state. Rest everyone has to be representative of the scheduled tribes themselves, and who gets to be a part of such councils has to be determined by adult suffrage. So there is going to be an election, and through election the members of such district councils are going to be decided, and it is this district council and regional council that is primarily going to be vested with the administration of such autonomous district. So the administration of these scheduled areas do not actually happen directly under the supervision of the government, but the government rather of these scheduled areas are autonomous district councils, which are run by the members of the scheduled areas themselves. So what we find is that much further autonomy has been conferred on scheduled areas and scheduled tribes in these 4 states of Assam, Meghalaya, Mizoram and Tripura. So this is the distinctive feature. So I hope at least you have a clarity in your mind with regard to how Schedule 5 and Schedule 6 operate and how these are example of asymmetric federalism, because what we find is that the kind of autonomy and the kind of decentralization of power that is happening in these scheduled areas is much different and much more than the kind of decentralization of power that happens primarily between the union and the state. So that is one important aspect of asymmetric federalism. Now, as we were discussing, let's come to the second example, something that we were discussing yesterday. Second example being Article 371. So I would request all of you to please open your barracks to Article 371 of the Constitution. And not just 371, but 371 till 371J. Okay, all these are special provisions which respect to specific states. So what you will find is that special provisions are made with respect to certain states, so that in case there is any kind of inequity or inability of the states to vis-a-vis the resources or any other aspect, or whether if they are not developmentally as sound as compared to other states, special provisions can be made by the union wherein generally what we find is that more funds are allocated for the development of these states. The union is more concerned about the development of the state. It is very similar to, for example, if parents have two children and one child is extremely sick. Now the concern of the parents is going to shift towards the child who is sick, because that child needs extra care and protection. Very similar to that, what happens is, what union does is, if there are certain states who need extra care and concern and protection because they do not have the resources to come at par with the development in other parts of the country, then these are the provisions which enable the union to provide extra aid and extra care for these specific provinces. So if you look at 371 running to 371, you will find the mention of states of Maharashtra, Gujarat, Nagaland, as well as Assam, Manipur, Andhra and Telangana as well, which an amendment which is made in the marginal note of Article 371D. Then we find Sikkim. Now, as if you know, Sikkim was not a part of India. Initially, it was only in 1975 that Sikkim became a part of India. And we'll also be discussing one judgment vis-a-vis Sikkim when we come to Unit 2 of your syllabus. 371, Mizoram, Arunachal, Goa and Karnataka. So these are the states which have been given special provisions have been made vis-a-vis these states, so that the state can allocate more funds to it, for example, and the treatment of these states will be definitely different from the treatment of other states, while more funds would be allocated to these states for the developmental purposes. So again, an example of asymmetric federalism. Now the third aspect that we will discuss is Article 370 of the Constitution. Now, obviously, Article 370 has been abrogated, and the issue with whether the abrogation of Article 370 was constitutional or not is still pending before the court. And we will also be discussing Article 370 in detail when we come to Unit 2 of the Constitution of our syllabus, when we will be discussing state and the territory and what is the power of the state of the union to alter the boundaries of the state, and whether the union also has the power to change the status of a state to a union territory. Okay, these are few things that we will discuss. But for the time being, what you need to understand that Jammu and Kashmir became a part of India in a very different manner as compared to other states. So we have these three examples of Junagadh, Hyderabad, and Jammu and Kashmir, wherein all these princely states were still contemplating, and rather they were not. Some of these states like Hyderabad had, at least the Nizam of Hyderabad had decided not to become a part of India. So whereas there was a military intervention in Hyderabad, there was a referendum in Junagadh, and there was a treaty of accession signed between Kashmir and India in the case of Jammu and Kashmir. So even the manner in which different states of India have become a part of India is different. It's not the same. And that perhaps explained why even in our constitution different treatment has been meted out to different parts of provinces of India. Now Jammu and Kashmir became a part of Union of India through a treaty of accession. And when it initially became a part of the Union of India, the terms of becoming a part of India was that it is only a very limited power that will be conferred on Union of India, on Republic of India, and rest all the power would be retained by Jammu and Kashmir. And therefore Jammu and Kashmir has its own constitution, has its own penal code. All these were the requirements, or all these were the terms and agreements under which Jammu and Kashmir became a part of India. But subsequently what happened was that by passing a resolution in the Legislative Assembly, subsequently many of the powers were eventually transferred to the Union of India, such that the distribution of legislative power and also executive power between Union of India and Jammu and Kashmir and Union of India and other states of India became more or less the same. Now, I would not discuss the constitutionality of Article 370. I'm sure you have several questions in your mind, but I think the better place to discuss the validity of the governmental move on abrogation of 370 and how Jammu and Kashmir's use territory, whether it is constitutional or not, is something that we will definitely discuss, but discuss when we are discussing our Unit 2, because that is where you will at least have much more idea on Article 1, 2, 3 and 4, because those articles need to be invoked while discussing the constitutionality of these provisions. So this is at least a brief overview of asymmetric federalism. Now as we move further in the syllabus, concepts will be clarified more, but at least I hope you understood what asymmetric federalism is about and you have a fair idea. And please, if you have any questions, let me know. So in the meanwhile, I'll answer Basant's question. In Keshwan and Bharti case, the ratio of the case was 7-6, so further can government reference matter to a larger bench and then change the constitution? Yes, so Basant, that can be done. So basic structure doctrine can be, or this concept, this Keshwan and Bharti judgment, and the government can't per se refer it to a larger bench. The government can only ask for reference to the larger bench. It is the Supreme Court itself who will decide whether Keshwan and Bharti should be referred to a larger bench. The government does not per se have a power to refer the matter to a larger bench. Okay, so it is the judiciary itself who decides whether a matter should be referred to a larger bench or not, and then the decision of the judiciary is final. So, yes, that can definitely be done. That there may come a situation in future wherein a larger bench supreme decision is given which overrules basic concept doctrine of Keshwan and Bharti. That can definitely happen. So basic structure doctrine is not fixed in time. Let's say 15-judge bench can declare Keshwan and Bharti to be overruled in a subsequent case wherein it may say that basic structure doctrine is no longer the law of the land. That can definitely be done. Okay, Piyush, explain Schedule 6. Yes, Piyush. So, now, as I said, Schedule 6 is an example of asymmetric federalism. If you look at Article 244, Clause 2, Schedule 6 is only applicable on 4 states. Okay, those 4 states being Assam, Meghalaya, Tripura, and Mizoram. Now, when you look at Schedule 5, Schedule 5 only provides for the constitution of a tribes advisory council. But the power given to, but the kind of autonomy which has been provided in Schedule 6 is much more as compared to the autonomy which is provided to scheduled areas in Schedule 5. Now, the reason being that one of the reasons which is often cited is that while many of the scheduled tribes or the tribal population and the indigenous population in scheduled areas in states apart from Assam, Meghalaya, Tripura, and Mizoram have some kind of resemblance with the mainstream culture and mainstream way of life, and they have sort of merged into mainstream culture and way of life. The scheduled areas and scheduled tribes of Assam, Meghalaya, Tripura, and Mizoram still retain a very, very clear distinctiveness, and they have not, and you can very easily distinguish those populations from the mainstream population. And if someone is in the class who belongs to these states, maybe they will be in a better position to explain. So maybe if there is someone who belongs to is a resident of that state, maybe they will be in a better position to explain that how there is a cultural distinctiveness attached to such scheduled tribes and areas. That's why if you look at even the history of Northeast, there is a lot of movement which happens for autonomy. For example, the entire movement of Nagas and the demand of Nagas to have more autonomy. Nagas, Bodos, so all these scheduled tribes, basically the demand for more autonomy is based on this aspect that they do not, the only manner in which they can retain their distinctiveness is if they have more autonomy. That's why what you find is that Schedule 6 provides for provision which allow the declaration of autonomous districts in autonomous regions. Now, this declaration basically, now in such autonomous areas, there are district councils and regional councils. Now, if you look at paragraph 2 of Schedule 6, what you will find is that each district council for such autonomous district can have a maximum of 30 members. And of those 30 members, only 4 are nominated by the governor. That means that the government representatives are only 4. Rest, all the 26 members of those 30 members have to be elected on the basis of adult suffrage. So election is done, direct election of the members of those councils. So basically, the first unit of governance in such autonomous district is district councils, which is directly elected by the by the members of the scheduled areas. And the power of these district councils as well as the regional councils is much more as compared to let's say local governments in other states, or even the power given to scheduled areas in the schedule. Again, because we need to maintain the distinctiveness of these areas. So if you look at paragraph 3 of Schedule 6, what you will find is that it mentions powers of the district councils and regional councils to make law, right? And if you look at what are the powers given to district councils and regional councils to make laws in scheduled areas, several aspects are covered. Now, what are those aspects? And maybe by reading these points, you will get a better picture of what are the areas on which these councils can make law. So one is allotment, occupation, and use of land. Because now land completely goes into the domain of these district councils and regional councils. So the government cannot in itself go ahead and make a law with regard to usage of these land, but the power to make laws on land, usage of land, occupation of land rests with the district and regional councils. Second, management of any forest not being a reserve forest. So how the forests are going to be managed. Use of water resources, practice of chum or other forms of shifting cultivation, establishment of village or town committees and councils, any other matter related to village or town administration, including police, public health and sanitation, appointment or succession of chiefs or headmen, inheritance of property, marriage and divorce, social custom. So even inheritance of property, marriage and divorce, social custom, that means the personal laws are also something that fall within the competence of the district and the regional council. Understood? So what that means is that the state government does not have the power to bring about changes in the personal laws. Rather, the laws of these scheduled areas are to be decided by the district and regional autonomous regional councils, whose members are the members of the scheduled tribes themselves. Now, such kind of autonomy you do not find in the rest of the country. So, because such why is that? Because of the special distinctiveness, the need to maintain the distinctiveness of their culture and to accommodate the needs and aspirations of these people, which may not be similarly placed as compared to the population in the rest of the part of India. So I hope Schedule 6 or the importance and relevance of Schedule 6 became clear to you. If not, just let me know. In the meanwhile, I will answer Pratishtha's question and I'll explain Schedule 5 again. So Schedule 5, as I said, is nothing but Schedule 5 is only provides for administration and control of scheduled areas and scheduled tribes, which does not include Assam, Meghalaya, Tripura and Mizoram. So apart from these 4 states, scheduled areas and scheduled tribe in the rest of the country are going to be governed by the provisions of 5th schedule. Now, unlike the constitution of autonomous councils in Schedule 6, scheduled areas in the rest of the country are going to only have tribe advisory. The administration and control of the scheduled area is going to have tribes advisory council, and the tribes advisory council, as we already saw, 3/4 of the members of the such tribe advisory council are going to be members or representatives of the scheduled tribes. Now, one extra qualification is required that in order to be a member of this tribe advisory council, not only do you have to be representative of the scheduled tribe, but also be a member of the state legislative assembly. However, let's say if the state legislative assembly does not have sufficient amount of representatives of those scheduled tribes, So in order to fill the remaining vacancy, let's say there are maximum number of members who can be a part of private advisory council is 20, and 3/4 of 20 is 15. Now, if there are 15 representatives of scheduled tribe in the state legislative assembly, and there are, let's say, only 10 representatives, so those remaining 5 members will still have to be members of these or representatives of the scheduled tribes, and they will be selected, and that vacancy will be filled by other members of those tribes, but they have to be members of those tribes. So again, because as representation, see, in governance, representation becomes very important, and generally, if the marginalized or the subalterns can only play a role in the governance if they are duly represented, and representation lies at the crux of all these exceptional or differential treatment which is which is given out to provinces and even given out to individuals in the form of affirmative action. So in order to ensure that the Tribes Advisory Council has representations from the scheduled tribes, such provisions are made. Now, however, you will find a distinct difference between Schedule 5 and Schedule 6 in the sense that Schedule 5 talks about Tribe Advisory Council and is not providing the kind of autonomy which is generally provided to scheduled areas in the 4 states, Assam, Mizoram, Tripura, and Meghalaya. So, and if you look at paragraph 5 of Schedule 5, what will you find is that in paragraph 5, it is possible that the governor of that particular state in which the scheduled area is may declare that certain laws will not be applicable on scheduled areas, and those laws can be both union laws and state laws. They will not be applicable on those scheduled areas. So an exception can be made with regard to applicability of law in scheduled areas. Okay, so that can also be done. Regulations according to paragraph 5 can be made with regard to, again, transfer of land, allotment of land, and carrying on of business. So all these are exceptional protection which is provided, different kind of protection which is provided to scheduled areas under Schedule 5, which is very similar to the protection that is provided to other provinces and other states and other areas in India, which do not fall under Schedule 5 or per se Schedule 6. So just let me know, Pratishtha, if that was clear. If not, again, as I always say, I will explain it again. Yes, Ravikant, the reason behind giving special provisions to few states under Article 371, mainly because they may be not developmentally sound. Okay, that is one of the reasons. Or there may not be sufficient allocation of resources. So, for example, you must have seen that before every election, at least in Bihar, there is this call for giving special protection to the state of Bihar, or giving special provisions to state of Bihar. And several other states also call or argue for special protection being provided to them. So one of the main reasons why special provision is made for few states under Article 371 is so that the requirements, so they may be deficit in natural resources, they may not be as developed as other provinces or as other states, and so that we can bring those states at par with other states because the development or the progress of India as a nation depends on development and progress of each state in itself. Now, that's another question, that how we understand development and how our present understanding of the concept of development is in itself problematic. Not keeping that in mind, the logic or the rationale behind having special provisions given to certain states is specifically this, so that it's only when we provide for special protection for these states, more funds can be allocated to them. So, for example, let's just pick up Article 371 and look at what are those special provisions which is provided. What does it say? That notwithstanding anything in the Constitution, the President may by order with respect to the state of Maharashtra or Gujarat provide for any special responsibility of the governor for the establishment of separate development boards for Vidarbha, Marathwada, and the rest of Maharashtra, as the case may be, Saurashtra, Kutch, and the rest of Gujarat, with the provision that report on the working of each of these boards will be placed each year before the State Legislative Assembly. Why? Because these may be lacking behind in development. So that is one of the reasons. Then clause B, equitable allocation of funds for development expenditure. So the reason why special provision is made vis-a-vis Maharashtra and Gujarat, as you can see, is to bring those regions at par with the rest of the India, so that they don't lag behind in this developmental, in the development project. So that is one of the reasons. Similarly, if you look at 371A, state of Nagaland. Now Nagaland requires a different kind of protection, which is not just based on developing them or providing them economic impetus, but also because Nagaland has a distinctive culture and there is a requirement to protect their distinctiveness. So what do we find in Article 371A? That notwithstanding anything in the Constitution, no act of the Parliament shall, in respect of religious or social practices of Nagas, customary law and procedure, administration of civil and criminal justice involving decisions according to Naga customary law, ownership and transfer of land and its resources shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. Again, a differential treatment, something which is not found under 371 but is mentioned under 371A. So this provision is not something which is made with respect to Maharashtra and Gujarat, but 371A clause 1 talks about protection of the customary practices and laws of Nagas to an extent where union law does not become automatically applicable. Union law will only become applicable once the Legislative Assembly of Nagaland adopts the union law and passes a resolution adopting the union law. Now, such power is not given to other states. So, for example, if there is a law made by the Parliament on list 1, which is very well within the legislative competence of the Parliament, the state legislative assembly don't need to pass a resolution for those laws of, let's say, Uttar Pradesh, do not need to pass a resolution for that central law to become applicable in state of Uttar Pradesh. It automatically becomes applicable. But that is not the case with state of Nagaland. In state of Nagaland, they have given additional protection to the Nagas. So Rabika, so you will see, and each provision of Article 371 will have a different kind of protection which is contemplated of. All the provisions of Article 371 do not talk about homogeneous special provisions, but rather keeping in mind, again, as I said, demands and aspirations of different individuals of such different provinces, different kinds of protections and special treatment has been accorded to these states. So that is one of the main reasons. There is no one specific cause. So development is not the only reason. Protection of customary practices may be another reason. Allocation of resources may be another reason. Region, etc., etc. For example, with respect to Telangana, one of the requirements and one of the reasons why there was so much assertion for a Telangana identity was